Good evening. This is Laws 11046, Environmental Law, and tonight we're dealing with Chapter 8 and Chapter 10 from Bates' book in relation to regulation of land and resources, heritage and natural resources. The material will be the subject to chapter reviews, and I do intend to complete a chapter review in relation to each one of the chapters of Bates' textbook. Chapter 8 has already been uploaded onto Moodle. I won't therefore repeat the content of that. And Chapter 10, which is in much more detail dealt with in week 9, will be uploaded to week 9 for the material. Thank you for those of you who completed your examination, your assignment. The assignment was done, I think, generally very well. There are a few issues that I'll raise. Those of you wanting to get feedback in terms of marks have received that feedback and hopefully some guidance in terms of how to go about completing your second assessment piece, which I understand is due on the 21st of May. The assessment piece was generally very high, as mentioned. The way in which it was marked was on a number of factors. In terms of presentation, that is important for me. I think I've made comment before about the cost that experts and lawyers in particular will charge, so it needs to be presented well, and that's something which I think can't be undersold. Have a look at my sample paper. It's not the best. Students have presented far more beautifully, professionally presented papers, but the sample paper that I prepared provides you with some guidance in that regard. In terms of marks, people have on some occasions gained extra marks because they've read very widely, and I think that's something that you might aspire to. That was probably more relevant to the Vegetation Management Act question than the Predajon case, but still important in both contexts. Referencing was not a huge part of the assessment piece. I was happy to accept Harvard or the legal citation method, but referencing is still important, and the way in which quotations was extracted and used is also something to consider. Ultimately, of course, the main point of the exercises was in relation to case law and legislation respectively, to identify how those parts of our law, the common law and legislation, come together in a real sense, in a practical sense. And a big part of the exercise, from my perspective, was whether students were able to identify the appropriate legal issues. And some students, I must say, did that very well. Once you've identified the legal issues, then it's a matter of drawing the appropriate conclusions based on that material and identifying how, say in the Predajon case, His Honour went about applying the law to the facts in that case. The same thing applied in a different way to your critique on the Vegetation Management Act. I was very keen to determine whether or not I was of the view that you were able to understand the concepts which were dealt with in that case and in the legislation, and whether you obtained a deep insight into how that law was applied in those cases or in those instances. There were a few things that people lost marks for. Again, go back to the sample document. I won't repeat all of those details, but apart from literally getting the answer wrong, which didn't happen very often, there are some issues about the way in which legislation was presented and discussed, and also the case law. But overall, very good feedback, and I was very happy with those results. So thank you very much. In terms of preparing for the exam, remember it's an open book exam. I will from time to time provide you with some issues that need to be considered. For example, tonight I'll be touching upon issues that might be of relevance to litigants involved in the Planning and Environment Court sphere. And ultimately, from a lawyer's perspective, that's very important. Now, for the purposes of this course, while I'm conscious of the fact that I'm not talking to lawyers, I do want you to understand the way in which lawyers work and the way in which cases are prepared and presented. In that regard, the role of experts is particularly important, and I'll be discussing a few things in that regard. Now, experts in planning and environment context are called upon to provide opinions in relation to a wide range of areas. It might be in relation to fauna and flora, it might be to do with ecology, it might be to do with natural resources generally, the way in which stormwater management is done, might be planning generally, or traffic issues. So there's a whole range of different things that can be the subject of expert evidence. We often refer to expert evidence as opinion evidence, and the reason we say that is that, contrary to the general rule where a witness is precluded from providing an opinion, there is a special exception for experts who are in fact lawfully able to give evidence in a court, which is their opinion. In order to do that, the court must be satisfied that the person in question is in fact an expert. So there is that preliminary issue. So from the context of applying what we're doing in this course in a real sense, when the course is finished, if you're practicing in environmental law, certainly from a lawyer's perspective, you need to think about what is going to be needed to persuade a court that your case is correct and that your arguments are correct. And very often for planning and environment, that means getting experts to give evidence and support a certain view. I make that comment very guardedly because of the way in which experts must approach their task, and they must ensure that they are not there simply to support a client's view, but to bear in mind their role and their duty to the court overrides any duty that they might have to the party who paid them. So when we talk about experts being called to support an argument, it is subject, of course, to that very important statement that experts must be objective, and they must present accurate information and truthful information to the benefit of a court. All right, so if an expert is called upon, then they may need to do a number of things. They might need to provide a preliminary statement of opinion in relation to, let's say, a proposed development. And who knows, even though you may not be lawyers acting in environmental law cases, students in this course may be called upon to give evidence as experts. And it's a considerable industry which has grown over the years, where people are essentially expert witnesses and are paid, I think, very well for doing so in some instances. So experts may have to give that preliminary report, may have to give that preliminary opinion, and that may effectively stop the development there and then. But if the application to develop proceeds, then assuming that the matter is litigious, it goes to court, there are a number of things that the expert would need to do. Site inspection, perhaps a meeting of other experts, preparing a joint report with other experts, and of course giving evidence at the hearing after they've provided a statement of their evidence, generally in written form. So experts can be very expensive. As I mentioned before, many people are using their expertise to fund a very good living. So it's really important that you select, if you're the lawyer, select the right expert, and credibility and expertise comes into play in this regard. Also, you need to be acutely aware of the regulations which relate to the way in which evidence is presented to a court. And in that regard, I refer you to the Planning and Environment Court Rules of 2010. Now, these are rules that apply perhaps generally to the conduct of planning and environment law cases, and they are also to be read in conjunction with what we call the Uniform Civil Procedure Rules. Now, it might sound a bit boring, dealing with rules and regulations, but it really is very important. And if you're involved in litigation, you need to be aware of these particular regulations and these particular rules that I'm referring to. So in the Planning and Environment Court rules, have a look at Part 3, and that starts at Section 22. So in Section 22, there's reference to the fact that an expert is a person who is qualified to give an opinion, evidence, as I mentioned before. And there's a definition there of what is meant by a joint report and a meeting of experts. The meeting of experts I've mentioned a couple of times. The importance of that is this, that under our rules in the Planning and Environment Court, it is likely at the first direction hearing that a judge will order the parties to disclose who is going to be the expert to provide evidence in relation to certain aspects and what that expert will cover. If there's a commonality of issues that are raised at that stage, then it's likely that the court will order a meeting between those experts, which typically must happen in the absence of parties, and typically the experts will be required to provide a joint written report. So this is all covered in, as I said, Section Rule 22 of the Planning and Environment Court rules. So the meeting of the experts gives them an opportunity to discuss the issues, share their opinions, perhaps even attempt to come to an agreement about those issues. So the experts need to assist the litigants by saying, well, here are the issues, here are the various views, and here is the ultimate conclusion. Those meetings of experts may or may not be chaired, if you like, by the ADR registrar, ADR meaning Alternative Dispute Resolution Registrar of the P&E Court. So if you find that you're a litigant up against a developer, let's say you're a submitter, you're an objector, and you're up against a large corporation, you may be able to fund an expert who is relatively inexperienced. In those circumstances, you might want to make an application that the ADR registrar does in fact convene the meeting to ensure that your expert is not perhaps bullied or intimidated by the more experienced, perhaps more high-powered experts on the other side. Anyway, the idea of the expert conclave, as we call it in QCAT, is to provide this report, this joint report, which is then used for the benefit of the court. Now, one obvious difficulty is if you're a litigant trying to take on a company which is proposing a development, let's say you're an objector, then typically the objectors don't have the sort of money or resources that the developers do have, and occasionally they may find themselves litigating without an expert, and that's a really difficult situation to be in, because understandably courts will often defer to or consider the evidence of an expert where there is some doubt or uncertainty as to what is the scientific situation in relation to a particular issue. So in the context of what people might do if they're involved in litigation, if you've only got money for one expert, then choose perhaps your strongest point, your strongest argument, and support it with that expert evidence. I should just say that generally speaking, unless you get leave of the court, you are precluded from calling more than one expert on a particular point. So keep that in mind. But in the context of an application for a development where environmental law is concerned, there may be many issues which should be the subject of, or could be the subject of, expert evidence. So there might be issues to do with fauna or flora, or waterways, traffic architecture, whatever it might be, you're entitled to bring in a separate expert on each one of those topics. Now, of course, there becomes a grey area. If you're talking about fauna, for example, there may be issues about the effect of a proposed development on certain animals as opposed to other animals. So then the question is, can you bring in an expert on each of those different areas? That's a matter for the court to decide. So if you've only got the money for one expert, choose perhaps your strongest issue and think about ways in which you can get round the issue of calling expert evidence. So one way that you might do that, for example, is to call upon evidence of people in the area. So if you're trying to establish to the satisfaction of a court that certain fauna will be adversely affected as a result of a proposed development, then you can call an expert to say, yes, this is the fauna, it will be affected. But you might be able to call upon witnesses in the local area who have seen certain numbers of fauna in certain areas, and you might see the way in which that fauna has been affected through their own observations, not giving opinion evidence, but just giving factual evidence. And that might be a way to get round the issue of not being able to afford a number of experts in a different area. So when you do get an expert, make sure that you brief the expert properly and comprehensively so that the expert is able to provide you with the best value. And perhaps that expert can provide you with some idea of the sort of questions that need to be asked if the matter ultimately does go to trial. All right, so I mentioned that the Planning and Environment Court rules are worth a look. Rule 22, I've mentioned, talks about the joint report and this expert conclave. There may be another issue, and this is touched upon in Rule 23. It may be that you don't need to call an expert in relation to something which the court can be convinced is unnecessary. It's not necessary to call an expert. So just bear that in mind, that even though in a case you need to prove your case, it may be that an application can be made to a court for a ruling that it's not necessary to prove certain things because they're not seriously in dispute, or proving that particular fact may cause unnecessary or unreasonable expense or delay or inconvenience. And that's all referred to in Rule 23 of the rules. Rule 24 talks about the meeting of experts being chaired or not chaired by the ADR registrar that I mentioned before, and the fact that the court can order or direct a meeting of experts. So if you're giving advice to people involved in litigation, not only do you need to consider the question of expertise, but you need to consider the question of how you go about technically using that expertise, whether you do ask for the conclave, the meeting of the experts, and whether you ask for the ADR registrar to be involved as well. So Rule 26 talks about the party being able to ensure the expert is ready to take part in the proceedings, and that makes sense. Rule 27 talks about the joint report and admissions during the meeting. Generally speaking, the conclave, as I'm calling it, between the experts is confidential in terms of what's said during the meeting. The report and the conclusions become admissible in a court of law, but generally speaking, what is discussed specifically, perhaps compromise offers and arrangements during that meeting of experts, is admissible at the hearing only if all parties to the proceedings agree. Otherwise, it is only the report and the conclusions that are drawn in that report that is admissible. So the experts are required to provide a statement of their evidence, and the Uniform Civil Procedure rules do apply in that regard as well. The comment that I made earlier about there being only one expert able to be called is found in Rule 34 of the rules. Then it goes on to talk about the way in which the evidence is presented, and I'll just talk about that generally as well. So tonight I'm really talking about some of the issues that need to be considered or raised in the context of litigation. So apart from expert evidence, there would be a need, generally speaking, to consider an issue of disclosure. Now, disclosure is where a party to a proceeding is required to provide the other party to that proceeding with all relevant documents in their possession or control that is directly relevant to the issues in the proceedings. Now, that's Rule 211 of the Uniform Civil Procedure Rules. What it means is this, that if you're an objector, if you're a submitter, if you're trying to challenge a development, then it's very important that you go through this disclosure regime so that you can extract from the other side relevant documents that have a bearing on the case that should be considered by a court. And there is an obligation on both parties to the litigation to disclose those relevant documents. And what happens from a practical point of view is the documents are referred to in a list of documents. Now, once you've got your expert evidence together, once you've been through the disclosure obligations, you've got your list of documents prepared, then you may need to, and probably almost certainly would need to supplement what you've got with some affidavit material. Now, the affidavits are sworn statements, meaning on oath, and the effect of an untrue affidavit is the same as an untrue statement in court. So both have that effect of potentially rendering a person liable to obstructing the course of justice or at worst perjury. So when you're preparing a case, you want to prepare written statements from witnesses or perhaps even affidavits. Affidavits are things that can be filed in court as evidence. But bear in mind that general rule is that unless excused by the other side or the court, a person who is giving evidence by way of affidavit will also need to support that by being at court to give that evidence so that they can then be subject to cross-examination. The risk is that if you don't have that person available for cross-examination, then in those circumstances the court may not be prepared to consider the evidence as strongly as it otherwise would. So that's just another issue that you need to take into account. All right, so tonight we've talked about the way in which experts have a bearing on the presentation of a case, and I make those comments in the context of the work that we're getting into in our course dealing with regulation of land and resources, development versus the environment, environmental impact assessment. These are all litigation type issues potentially, and that's why I think it's important to think about the role of an expert and think about the way in which expert evidence is given. All right, well, please continue to provide your information and comments through UCREW. I think we have the examination date is now set, I believe the 18th of June. I will be providing chapter reviews on an ongoing basis, so please look out for that. And think about, from the context of an exam, think about maybe some of the problems associated with a person who is involved in litigation having to prove their case. And so I hope tonight's commentaries have provided some assistance in that regard. All right, well, I'll now stop recording, and thank you very much for listening.